Hi everyone, my name is Yusuf Oluwafemi Salako, popularly known as Oridemi. I'm a legal practitioner and an academic consultant, and I welcome you all to my YouTube channel. Today, I want to explain, or I want to say one or two things on the different types of companies that we have in Nigeria. And the idea is that when you have decided to pursue that commercial interest, that is, if you have decided to do a business, to engage in a business, or if you have decided to engage in charitable causes, you're not essentially doing a business, you're just trying to assist humanity, promote art and culture, you're trying to promote sports, or whatever other altruistic purposes that you have decided to promote, you need to define, or you need to determine what model that you are going to use to pursue that objective. And what I mean is, when you decide to do your business, if for example you're the only one that wants to do that business, you can decide to register it as a business name. At least you can act as a sole trader, or you may decide to register that business as a company, because the law allows a one-man company. Or if you're more than one, say 2, 3 people have come together, you can decide to do that business as a partnership, that is as a firm. Or you guys can decide to register a company. So for today, I want to explain to you the different types of companies that are available. So it's not enough that you have decided to register a company. You need to also be able to determine what company or what form or type of company best suits your circumstances. So when we speak of the different types of company in Nigeria, the first company that we have is what we call a private company. A private company. So you can have a company that the law recognizes as a private company. And what does it mean when we say that a company is a private company? When you look at the law really does not, at least the Companies and Allied Matters Act 2020 as amended, does not exactly tell us what a private company is. It basically just says that, well, a company is a private company when you state that it is a private company. And you state that a company is a private company in the Memorandum of Association. The Memorandum of Association is a constitutive document of the company. And this is a governing document of your company. So you state that, the company that I want to register, that I want to incorporate, is a private company. But that necessarily does not help you in determining whether, for your own situation, a private company is the best vehicle to use. So it means that the meaning of a private company would then go beyond the provisions of the Companies and Allied Matters Act. But when we say a company is private, what exactly does it mean? It means that the company does its things, or the company is expected to do its things privately. And what that means is that for a private company, one of the features of a private company is the fact that it does not give room for explosion of members. Now, what this means is that there is a maximum limit of the number of people that can become members, that is investors, that is shareholders in a company that is a private company. According to the law, you cannot have more than 50 members in a private company. So it then means that if you're looking for a type of company where you don't want to open your door to the whole world, then you should be opting for a private company. You see, it makes it private. It's not for the public. Another feature of a private company is also the fact that when it comes to raising capital, yes, if you're running a business or you're even pursuing any altruistic or charitable purposes, you will need money. You will need capital. So companies raise capital in different ways. Many a time, you either go and borrow money, or companies can sell a part of themselves, which we call equity. So when a private company wants to also raise capital, the law says that a private company must also do it privately. And what does that mean? It means that a private company is generally not allowed to offer its shares or any other form of securities, whether debentures, whether bonds, whether notes, whether derivatives. The law prohibits a private company from going ahead to offer it to the whole world. So which means a private company cannot start making advertisements, calling on the members of the public to come and purchase its shares. Of course, by reason of the Business Facilitation Act and the Investment and Securities Act, you will come to then appreciate that when it comes to debt security, private companies are not allowed to go to the public and then make their offer to the members of the public. But generally, private companies are supposed to raise capital, particularly when it comes to selling their shares. They're supposed to do it through private arrangements. That is, you have to discuss with those that are closer to you, the investors that you know, but you don't make your shares to be open to the whole world. And what that also translates into is that for a private company, unlike a public company, you also not be able to trade your shares. That is, to allow the buying and the selling of your shares on an independent market, which is known as the stock exchange market. You are not also allowed to do that because you can't be listed, because that is a public domain. It's a public market. So the members of the public come to that place to see what stocks, what shares they can buy. The ones that want to sell, they also go on that platform to see what shares or who they can sell to. So it's an intermediary that brings together the buyer and the seller. A private company is not allowed to do so. Then one other feature of a private company is that your shares can be locked in a private company. And what does that mean? It means that the moment that you have purchased your shares in a private company, you may not have the freedom to be able to sell your shares when you want and to whomever you desire. You might not have that freedom. And the reason is that for a private company, they are allowed to restrict transfer of shares. And what that means is that a private company can state in their articles of association, this is also another constitutive document of the company. A private company is allowed to state it there that they cannot offer your shares to an outsider, to a stranger, without perhaps the consent of the board of directors. Or it could also be phrased in a way that it could be a form of preemptive right. And what that means is that it could also be that the restriction of the transfer of shares is that if you want to sell your shares, if we are all shareholders and you decide to sell your shares, the moment that you have decided that you want to sell it to somebody that is not in our company, that is not a shareholder, it could be that the restriction means you can't sell to an outsider, you can't sell to a stranger. What you need to do is to first offer those that are already within the company. So which means that even if you have somebody that is willing to buy it at a very high price, you can't sell. What you have to do is to make the offer to your colleagues, if I may put it that way, that is to the other shareholders of that company. So that way, you see that there is no free tradability of the company's shares in a private company. So it could be locked in. But unlike a public company, you have that free tradability, because restriction of transfer of shares is not something that a public company is allowed to insert in their articles of association so as to enhance free tradability of shares. In fact, one of the conditions of the listing rules is that if you want a public company to be listed on the Nigerian Stock Exchange, you have to ensure that there are no restriction of transfer of shares in your articles of association. So this is also another feature of a private company. Now, what that means is that if you want a company whereby no one can introduce a stranger through the back door and force it on the company, the private company is your best fit. Another feature of a private company is also that a private company is a company that is suitable for individuals that appear to have trust and confidence in one another, and they seem to have some sort of close relationship. So where two brothers, or a brother and a sister, or husband and wife, or two friends, colleagues, when they want to create or register a company to pursue a particular objective, a private company is more suitable for them, because that way they are able to ensure that they keep the membership of the company limited to what? To one another, and also ensure that you are not able to bring an outsider. And another thing is that when it comes to a private company also is more suitable where the capital involved is not that what high. So when you have a low capital to invest in, a private company is your best what bet. And the reason for this is, one, that the private company has what we call a minimum issued share capital of 100,000 naira, or should I say 100,000 naira. And what that means is that when you want to register a private company, all that is required of you in terms of the capital of the company is for you to show the Corporate Affairs Commission, CAC, that so person has agreed to take so number of shares that is worth so amount. So person has also agreed to take so number of shares that is worth so amount. By the time we sum all, or should I say, the value of the shares that these people have agreed to take in that company, it should not be less than 100,000 naira. So if Ori David agrees to what? To take shares worth 50,000 naira in the company, and say Adam has also agreed to take shares worth 50,000 naira, that is all that is required for you to be able to register a private company. But as you would also come to work to learn, for a public company, it is 2 million naira, and it also depends on the industry, because if you remember the last class that we had, I told you that we also have industry specific laws. So if you want to engage in what? In a banking business, or you are a financial institution, or you want to start what? Engaging in the capital market, of course, you do not expect that your minimum issued share capital would be 2 million. It would be higher. But today's class is not on minimum issued share capital. Another video, another class will address that. So this is also another feature of a private company. So you consider the relationship of the people that want to set up the business. You consider their financial strength as well. And also you consider whether they wish that the membership should be made what? Open to the generality of the public. Another thing is also that a private company is not stringently regulated compared to a public company. So because for a public company, the company is more like a vessel that now holds the funds, the capital of several members of the company. That means there is a state interest in it. So as a result of that, you see that public companies are rigorously regulated compared to private companies. So if you're also looking for that flexibility, where you don't have to always watch your back, where you don't have much regulatory responsibility, then you should opt for private company. And it doesn't even make sense if you know that you do not have that huge capital outlay. Then you go and register your company as a public company. The amount, the capital that is even needed for regulatory compliance itself for a public company is already high. So it means that the capital you should be using as working capital, the capital you should be using to run your business, or even what should serve as the profits, the returns to the investor, you would probably have just spent all this solely on what? Complying with regulations, and it doesn't make good commercial sense. So in that circumstance, then you may start as well as a private company, and as the fortunes of the company grow, then you can now convert to a public company. Yes, the law allows or permits private companies to convert to a public company, and even the reverse is also the case. You can also degrade from a public company to a private company. Then another feature of a private company, and which is also an offshoot of that flexible regulation of a private company, is that you then also realize that for a private company, the law recognizes the fact that, see, the people that are the shareholders, that is, those that set up the company or those that have invested in the company, who we may term the owners of the company factually, they are most likely to also be the one that will be on the board of the company. Yes, and the idea is that when you set up a company, there are two main organs of the company. And what do we mean by there are two main organs of the company? Yes, when you register a company, remember that a company is a separate legal person. I also make reference to an earlier video where I had explained what it means when we say the company is a separate legal person, which means the law treats a company as a person, separate from those that created the company. Separate from what? From the shareholders. So you then realize that for a company to be able to now live out its existence, companies will have to make decisions, and decisions are made largely across two levels. It's either at the general meeting, that is the meeting where you call the shareholders, the members, and they come and vote as to what the company should do. Then there is also the board of directors. The board of directors are the managers of the company. They are expected to have knowledge of how to run the business of the company, and they are actually the ones that make majority of the decisions on the business or commercial side of the company. So you find that many a time the people in a private company, the shareholders, would also be on the board. So at times it may not make sense that you always demand that when they want to take decisions should be taken first at the general meeting level, and they should also take it at the board meeting level. What that translates into is that you imagine a situation where, say, Khalil and Isaac have decided to register a company as a private company. They are the only shareholders. You now expect that they first take a decision at the shareholder level. They call a shareholder meeting and take that decision, and then they also now go to the board level again and take the same decision, or that they generally have to meet in person. No. So there is that flexibility in terms of the governance of a private company, and that is the reason you see that for a private company, when they want to hold a general meeting or they want to hold the board meeting, there is no need for it to be on site anymore. The law allows for electronic meetings. So you hold meetings on on Zoom, you hold meetings on Meet, on different other video conferencing tools. You don't necessarily have to meet in person, but for a public company, they still have to continue to meet in person. And in fact, for a private company, they don't always have to meet, even virtually. The law also allows for what we call a written resolution. That is, when Isaac and Khalil, they probably have even spoken informally over the phone. This is what we need to do. Why should they have to now set up a Zoom meeting and then hold the meeting? There is no need for that. So the law says they can just prepare the resolution. This is it. What we have discussed. They put it down in writing. That also this meeting, and that they should take it as if the meeting held either virtually or in person, as long as all the shareholders of the private company sign, all of them. So in our case, Khalil and Isaac, if Khalil signs and Isaac signs, it is almost as though they held the meeting either virtually or in person. So this flexibility is not allowed or is not available to a public company. So you need to understand the nature of a private company before you decide that, I want to register my company as a private company, or that I want to register my company as a public company. That is on one hand. Then another type of company is then the public company. The public company is a contrast to an extent to the private company. So if you're not registering your company as a private company, then you would be registering it as a public company. So when we speak of a public company, what does the law say as to how to identify a public company? The law simply says that any company that is not a private company is a public company. Can you see? If your company is not a private company, then your company will necessarily be a public company. So as far as Nigeria is concerned, and I'm speaking of registered companies, your company is either private or public, no in between. Company is either private or public. So if your company is not a public company, then it's a private company. And if it's not a private company, then it's a public company. Now, what is the content of a public company? The nature of a public company? Yeah, it does its things publicly. A private company does its things privately. So the idea is that in a public company, this is a company where the membership is what is open to the generality of the public. So anyone can buy shares in that company. So there is no maximum limit. So there is nothing like I can't have more than 50 members. No, you can have as many shareholders, many members as much as what you like. Now, for a public company, you realize that when it comes to raising capital, that is when the company needs money, and they need to get money from people. The public company is well positioned comparatively to the private company to raise higher capital, and the reason is not far-fetched. When you are able to offer your shares to the generality of the public, so you see that there are times that you hear that a particular company is now selling their shares. You see YouTube ads, you see the ads on Instagram, you see the ads on Twitter. That's also companies selling their shares. During the time sometime last year, when the Central Bank of Nigeria now rejigged the capitalization threshold, that is, they increased the capitalization threshold for companies, particularly banks. In that time, you see, in fact, there used to be that joke that you might just sleep and wake up and find that you now own GT shares. You don't just GT shares in your cupboard. And that was just an allusion to the aggressive advertisements and publicity that GT Bank as a company was doing. If you're on the highway, you would see this ad that looked like an orange, and a particular part of it is actually called, let's say, own a piece. That is a company. They are calling you to come purchase their shares. A private company is not allowed to do that. I remember one day I was heading to work, and I think at Obalende, I saw some ladies, and they were meeting people, trying to talk to people, and I saw that there was some sort of tag saying "Ask me about Fidelity shares." So that's also some sort of advertisement. So they're allowed to do advertisements, they do road shows, they prepare the advertisement document or the marketing document, which generally is known as a prospectus. So public companies are able to raise that much capital. But don't forget what I said, they are heavily regulated. And secondly, it's also that for a public company, there is nothing like a written resolution. When the members want to meet, they don't say, put it in writing and everybody will sign. How do you expect a public company can have 1,000 members? So how do you want to get every 1,000, every one of them to be able to sign, and all of them must sign before the resolution can pass as a written resolution? So there is nothing like written resolution for a public company. And also for a public company, they also have to hold meeting. And now this is where it gets tricky. Now initially, public companies were not allowed to hold their meetings electronically. They were not allowed to hold their meetings electronically. Only private companies were allowed by virtue of Section 240 of CAMA 2020. But the Business Facilitation Act has now amended that provision and has now made electronic meeting to be available to both private and public companies. And because the question is, who even needs an electronic meeting more? It's not the public company. The private company could just be 2 members, 3 members, 3 shareholders, 4 shareholders. It's not people that have about, say, 1,000. Do you always want them to meet or to converge in a single workplace? They are the ones that need this electronic meeting. So as a result of that, the act was amended. So now public companies can now also hold meetings electronically, but they are not allowed to They are not allowed to have a written resolution. And as I've also alluded to earlier, the capital would also determine. So for a public company, the minimum issued share capital generally is 2 million naira. But you see that it is also industry specific. If you are in the telecommunication sector, you realize that there is a minimum issued share capital for that. If you are into banking, you realize that the minimum share capital could even be what? Billions. In fact, if you have a foreign company, that is a company that has a foreigner, the minimum issued share capital used to be 10 million naira, but the revised handbook now provides for 100 million naira. And the Corporate Affairs Commission, sometime in 2023 or 2024, has then decided to now start effecting the provision of the revised handbook. Can you see that it may go beyond the 2 million naira? But if you are looking at the general threshold for a public company, when it comes to the minimum issued share capital, it is 2 million naira. So for a public company, there is nothing like you are restricting transfer of shares. There is free tradability of shares, and a public company can be listed. Yes, of course, there is no law that says every public company must be listed on the stock exchange. No, there is no law that says that, but it makes good commercial sense that when a public company wants to raise capital, that you should go to where the buyers are. If there is a platform where you have the buyer, that is where you should go and say, this is what I have, this is what I am selling, because the stock exchange market here, that particular market, is a medium to bring the companies that want to sell their shares, and also bring the buyers that want to buy their shares, and other stakeholders like brokers, the lawyers, those that would assist in the sale of the shares. So as a result of that, you see that most public companies would want to get listed. And so for you to be listed, you cannot be having any form of restriction on your transfer of shares. So it means that when you own shares in a public company, you can easily, at least easy here is now relatively to a private company, you can easily sell it when you want. You can easily trade it. So these are some of the things that you consider for a private or public company. And generally, you realize that the names of a company should also tell you whether it is a private company or a public company. So from the name, you should already be able to tell whether, you should even be able to know whether it's even a company in the first place. So take, for example, you have Ori David Consult with nothing more to it. And then you have Ori David Homes Limited. So there is Ori David Consult and there is Ori David Homes Limited. Now, the name of the company is itself Ori David Homes, but you have something called Limited. So maybe tomorrow you can have Ori David Consult PLC. So it means that from the name you should be able to tell whether it is even a company in the first place and what type of company it is, whether it is private or public. For example, if you have a private company and that private company has share capital, that is, the company can sell shares, then you have limited or LTD after the name. So Ori David Consult Limited, Ori David Homes Limited. So once you see limited or LTD, it means that that company is a private company and that company is in business. It has share capital. You can buy shares, the company can sell shares. And if you have PLC, that is public limited company, you have it at the back of the name of a company. So Access Bank PLC, that shows that it is a public company that has shares. So from the name, you must also know that's the provision of section 29 of CAMA 2020. Now, beyond a company being private or public, the law also provides for different other types of company. So when we speak of type of company, it's not limited to private or public, although every company must either be private or public. Now, there is also the idea of classifying a company based on, say, the size of the company. And that leads me to what we call a small company. So a company can also be regarded as as a small company. Now, we see that earlier on, when I was distinguishing between private and public company, I was saying that, depending on the capital outlay, that a private company is more suitable where the capital or the investment involved is somewhat low, not that high, not that huge. And that when it is public company, particularly because they can raise more capital, and that might create an impression that a private company is a small company, then a public company is a big company. Not necessarily so you can have a private company that is more prosperous, that is thriving better than what? A public company. So when you want to even have a sense of a company being small, it is not necessarily the fact that it is a private company. And that is why the law has also now further classified a company to what we call a small company. But I should state this at the very outset, that a small company must also be a private company. So we can say that a small company is a type of a private company. If your company is a public company, then it automatically cannot be a small company. So that is the first thing that you need to understand. Every small company is a private company, but not all private companies are small companies. So just because I am a private company and your company is also a private company, does not mean that what we are made to shoes get size. So you might probably also have to appreciate whether yours is what? A small company, while I might be a private, my company might be a private company and it's not necessarily what? A small company. So, and the idea of a small company, there is a philosophy of what? Of a small company. And that's what philosophy is to what? Is to start small. Is to what? Is to start what? Small. To keep it what? Small. So because the law recognizes that for a small company you are starting small, it then means that the law provides for, or the law makes provisions that would allow those types of companies to what? To start small. It will not make good regulatory and commercial sense for you to treat a big company in the same way you treat what? A small company. No, you can't demand the same thing of a big company and what? A small company, because if you do that, what will happen is that you are going to stifle what? Life out of the small companies, and before you know it, the big companies are going to dominate the market and they are going to prevent what? Competition, because they would have the resources to be able to comply with the regulatory what? Requirements, while a small company will not be able to do that. So the only way to ensure that the big companies continue to also trade while also allowing small companies to have the opportunity to also enter into that market, to also what? Compete, is to ensure that you treat what? A small company as a small company and the big guys as what? As the big guys. So as a result of that, the law provides for what makes you to be a small company. So what are the conditions to being a small company? Well, when you look at what? The provisions of CAMA 2020, you see that it says that for you to be a small company, the first thing is that what? You must be a private company. And if you go and look at section 394 of CAMA, says that what? You must be a private company. So only private companies can be small company. And also another condition is that the annual turnover of a small company must not be more than 120 million naira. That's for the annual turnover. It must not be more than 120 million naira, or any amount that what CAC provides for. And also the net asset value must not be more than half of the annual turnover. So if the annual turnover as prescribed by CAMA is 120 million naira, it means that what? The net asset value must not be what? More than 60 million naira. So of course, net asset value is basically more of when they consider the total assets of the company and they deduct the total liabilities of the company. Whatever it is that is left must not be more than what? 60 million naira. Then for you to be a small company, none of your members must be what? An alien, more of a foreigner. So the moment you have a German shareholder, an American shareholder, you typically are no longer a small company. Then also, none of the shareholders or members of that company must be a government parastatal, a government ministry, a government what? Agency. Yeah, and please, this should not raise your brows. Governments is also allowed to invest in what? In companies. They can also be shareholders in companies. So you must not have that. Then if the small company has a share capital, the directors of the company, they must hold not less than 51% of the shares of that company. So these are the conditions that will make you to be a small company. So for a small company, the law treats it as small. So it creates what we call this opt-out system. Now, what does that mean? It means that the law might generally make what? A provision and say, oh, companies are to do this or do that, but then it will not exempt what? Small companies. So that is the way you are treating them what? Small. So that what? That philosophy of what? Start what? Small. so that it will make what? It will make sense, so that they can easily start small and be thinking of how they want to what? To grow. Let them start small first. So, and I think it is also very important that I state this, that while generally the law says that companies must have at least two directors, while you see that only small companies are allowed to have one director. And this should not be misconstrued to say, oh, public companies must have two directors, private companies are allowed to have one director. No. So only the small company. Yes, of course, a small company must be a private company, but not all private companies are small companies. So if you are a private company, but you are not what? A small company, don't fall into this category. You must still have what? At least two directors. But a small company is allowed to have what? Just what? One director. So this is also another type of a company. Another type of a company is also what we call the single member company, or popularly one man company, or maybe in Indian jurisprudence that they refer to it as what? One person company. And the idea is that only a single person can own all the shares in a company. So that I've handled cases or I've had clients where because of the challenges that they faced in respect of partnership, you see them saying, I don't want to even have to do any business with anybody. I want to do my thing alone, where I'll be the one to manage it. I don't want any other person to have investor. I don't want any investor also or thereabout. Now, the problem before, particularly under CAMA 1990, used to be that the minimum number of persons needed to incorporate a company was what? 2. So it means that even when you are the only one that you want to do the business, you're not going to look for someone. That person might not necessarily be holding shares because the person has invested in it or has any interest in the business at all. But because you want to meet that number, so you call maybe your younger brother or you call your parent, you just put their name just for the sake of it. But you don't need that anymore, because the law now provides for a one-man company. Only you, or what CAMA calls a single member company. So a single person can also incorporate the company and you fully own the shares. But I must state that a single member company can only be a private company. And many at times, a single member company is also a small company, most times. But it doesn't necessarily mean that they are one and the same, because you can have a small company that has multiple members. So we must not equate single member company with small company. But what you also see is that the opt-out system for small companies many a times also apply to to a single member company. So that is also another type of company, but it must also be a private company. Then another type of company is also in the sense of what we call group company or associated companies. So the idea is that you are allowed to create a company and then use that company to create other companies. So a company can give birth to several companies, and then they will all be pursuing some sort of uniform commercial interest as a whole, and that is what we call a group company. So the idea is that you can decide to register a company and you call that company, say, A Limited. And after you have done business for about 5 years and your business has prospered, and then you now want to delve into maybe another business. So, and you don't want your own company to now do that business. What do? You can create another company. But how do you create the company? That's your own company. We now own shares in the other company. So you have, say, A Limited, and now you are creating B Limited. So A Limited, we have shares in B Limited. It's not just that the shareholders of A Limited that they went to go and create B Limited. If A Limited does not own shares in B Limited, you can't be speaking of of a group or company. No, you can't. That means what you just have is just maybe affiliate or sister company. So the way you create a group company is in the sense that on the one hand there will be a parent company or holding company, and on the other hand there will be a subsidiary company. So there are times when you are dealing with a company, you should also be careful. You should check, are you dealing with a parent company or are you dealing with with the subsidiary company? Yes, if you have a company that is doing well and you guys want to engage in a business, I feel that this business that you guys want to engage in is very risky. So what you might do is that don't make this your company that is doing well be the one to go and do that risky business. What you can do is you create another company. This your company will now own shares in that other company, and then you do that business. So all those people that will be dealing with that other company, which is your subsidiary, what they might have in their head is basically that they are dealing with that big company, not knowing that they are dealing with the subsidiary, and when issues arise, they can hardly sue the parent company. They only have to sue the subsidiary company, of course, unless where the law is lifting the veil. But lifting the veil is also another topic that I will be explaining another day. So the idea is that a company can give birth to another company, and that other company too can give birth to another company, and they will all be working as a group. And that is the reason you see Dangote Cement. You talk about the company that has the refinery. You talk about the company that does manufactures sugar. The one that also manufactures noodles, all Dangote. So it's a group. That's why you speak of Access Bank PLC, and then you speak of Access Holdings, which is the group. So the law also speaks in terms of in terms of group company. That's also another type of in fact, you at times you can go to the market, and let us assume that, say, you want to buy a biscuit, and then you see a particular biscuit. I don't like this I don't like this brand. Their biscuit is not that nice. Also, let me buy from this brand. But what you might not know is that those two biscuits are produced by the same company. And when I say by the same company, I mean there is a parent company that has now created two different subsidiaries. And so one subsidiary is producing A biscuit, the other subsidiary is producing B biscuit. They put it into the market, and you are saying, I don't like this particular biscuit. I want this. And you think that maybe you are patronizing a different company. You are not patronizing a different company. You are still patronizing the same company. Because at the end of the day, they all work as a group. The money that still comes from that subsidiary A and that of subsidiary B, they will still have some sort of group account. And if depending on how it is structured, the money might still be going back to the parent company. So you are not necessarily avoiding that company. So some of you, the drinks that you buy, you want to go and buy I want a juice. I don't want so product. I want so product. I don't want this milk. I want this brand for this milk. The one you said you are not buying, and the one you eventually buy is also still produced by by the same company. So this is the concept of group company. And section 381 of CAMA provides for what must be in place before you can have a group company. So don't say because we have Ori David Consult, and we have Ori David Homes Limited, and then we have Ori David Academy Limited, it now automatically means that it's a group company. No. That's not the way it works. That's not the way it works. Simply because you see that you have about 3 companies and they have a common name. Doesn't necessarily mean they are they are group company. That is, it's not a parent or holding subsidiary relationship. They could just be referred to as sister companies. That is, they are owned by the same person or a set of persons. So for there to be a group company, one of the things is that the parent company must first be a member of the subsidiary, and the parent company must own shares in the subsidiary. That's the first That's the first thing. And the parent company should control the composition of the board of the subsidiary. That is, the parent company should have that unilateral power to be able to determine who becomes a director in that subsidiary. And also, if the parent company holds at least 51% of the shares in the subsidiary. So this is what I'm saying. You create a company and you say, Ori David Consult Limited. Then you now create another company, you say Ori David Homes Limited. Ori David Consult Limited now holds at least 51% of the shares in Ori David Homes Limited. It means that Ori David Homes Limited is a subsidiary of Ori David Consult Limited. And also, if you have a company that is a subsidiary to a subsidiary of a parent company, then that company also becomes a subsidiary of the parent company. This is what I'm saying. So, in the typical example I cited, Ori David Consult Limited was the first company. Then, he now created Ori David Homes Limited to provide for student accommodation. 2 different companies. However, Ori David Consult Limited holds 51% of shares in Ori David Homes Limited. That automatically makes Ori David Homes Limited a subsidiary of Ori David Consult Limited. Then if tomorrow, they now created Ori David Academy Limited, and then Ori David Homes Limited, not Ori David Consult Limited now, the subsidiary, Ori David Homes Limited, now holds 51% of the shares in Ori David Academy Limited, or Ori David Homes Limited is a shareholder in Ori David Academy Limited and controls the composition of the board of Ori David Academy Limited. It means that Ori David Academy Limited is now a subsidiary of Ori David Homes Limited. And Ori David Homes Limited is what? A subsidiary of Ori David Consult Limited. That means Ori David Consult Limited is the parent company. Ori David Homes Limited is a subsidiary of what? The parent company, which is Ori David Consult Limited. Then Ori David Academy Limited is a subsidiary of Ori David Homes Limited, which is a subsidiary of what? Ori David Consult Limited. That automatically also makes Ori David Academy Limited a subsidiary of Ori David Consult Limited. If a company creates a subsidiary and the subsidiary also now creates its own subsidiary, that second subsidiary is automatically a subsidiary of the parent company. And you can see this in section 381 of CAMA 2020. Then when it comes to type of company, you can also see a company in light of their limited liability structure. Yes, when you want to set up a company, whether it is a private company, whether it is a public company, whether it's a group company, whether it's a small company, whether it's a one-man company, as long as it's a company, you must determine the liability structure of that company. And what that means is that you have to create a company either limited by shares, or a company that is limited by guarantee, or a company that is what? Unlimited. So your private company may be limited by shares. Your public company may be limited by what? By shares. Your private company may be unlimited. If you look at what the way CAMA is worded, your public company may also be what? Be unlimited. So it depends on the liability structure. But before I start explaining what it means for a company to be limited by shares, or what it means for a company to be limited by guarantee, or for a company to be unlimited, let's even understand the concept of limited liability. When we say that a company has limited liability, or a company has unlimited liability, what does it mean? The idea is this. When a company has been incorporated, by now, for those of you that have been following me, we all agree that a company is a separate person. A company money is the company money. It's not owned by the shareholders. The company's assets, property belongs to what? To the company. So when we have already agreed to that. Now the idea now is that you see the shareholders in a company. When they want to invest, they invest in the company by purchasing shares in that company. Now it is possible that the company will have creditors. The company will go and borrow money from so person and they are owing. So it is possible that the company might not be able to pay. And when a company is not able to pay, inability to pay debt is a ground for winding up the company. Yes, incorporation is the birth of the company. Winding up and dissolution is the death of the company. So what has a beginning? At times, for companies might have an end, and there's a reason I said at times not every company will end up being wound up, or at least I'm not sure. So when the company is to be wound up, the idea of the company being wound up is to liquidate it. That is, sell all the assets of the company. And when you do that, what you have to do is to pay the creditors. Oh, the company is owing this, take your money. The company is owing based on their priority. There are times that the asset of the company might not be sufficient to pay all the creditors. Maybe after they have sold all the assets of the company, the asset of the company is worth 30 million naira. But the company is in debt of 100 million naira. It means that after paying the creditors the 30 million naira, that company will still be owing people 70 million naira. The question now is, for those that have shares in the company, or for those that have given an undertaking that if this company is in problem and is in debt, and this company is unable to pay, I undertake or I promise to pay so amount of money. For people like that, the question is whether the creditors, those ones that have not been paid, whether they can pursue their personal asset. So in the event that the company gets wound up and the company is now in debt of say 1 billion naira, all the creditors would expect that they would be paid. But the problem is that when the assets of this company are sold, maybe the total assets is worth 500 million naira. They take the 500 million naira and they pay the creditors. But the company is in debt of 1 billion naira. So which means the company will still be owing 500 million naira. Those creditors that are still being owed, they would want to ask, How can your company be owing me 500 million naira and you just bought one DNA? You just Queensley has just what? Bought one house worth 700 million naira, but your company is owing me. The question is whether the creditors can pursue the personal asset of the shareholders. So if a company has limited liability, it means that the liability of the shareholders, in the event that the company is in debt and needs to pay, their liability is limited to the value of shares that they have subscribed to. And what that means is that if you buy shares worth 1 naira in a company, if the company should enter any problem, so long as you know that that 1 naira share that you bought, you have already paid for it, the creditors cannot run after you. It does not matter whether you are richer than Dangote. That 1 naira is the amount that you are going to lose. That is the concept of limited liability. And of course, the opposite is unlimited liability. So if you buy shares and it's in a company that has what? Unlimited liability, you are exposing yourself. If the company cannot pay off the debt, they will come afterwards. Your personal, you will sell your car. That your money that is in your bank account, they will collect it, and you'll be like, it's not the company that borrowed you. Was it not the company that borrowed money from you? And they will tell you that the company is unable to pay, so you will have to pay. The reason is that you have not limited your liability to the value of shares that you have bought in the company. That's the first. And the second thing is that the law now says that for a limited liability, there are two types. There is a company that is limited by shares. Now, what does it mean when a company is limited by shares? The company has share capital. It can sell shares. People can invest in the company by buying shares. Now, most time, well, not necessarily most time, the fundamental feature of a company that is limited by shares is actually that kind of company is set up for the purpose of doing business, making profit and sharing the profit amongst the shareholders. So if you really are an investor and what you are interested in is in trading, you just want to put 2 naira here to be able to get 10 naira, then you are looking at a company that is limited by shares. They are designed to do business, make profit, and then share the profit amongst the shareholders. So there is distribution of profits. Of course, there are other features, but this is generally what a company limited by shares is. Then you also have a company limited by guarantee. If you are interested in doing business, but the reason you want to do that business is not necessarily because you people are looking for returns. It's not necessarily because those of you that you have set up that company, you are looking to enrich yourself. Instead, you're doing the business so that you can raise funds for you to be able to pursue some charitable objectives. And a foundation, NGOs or so. You say, you want to ensure that no law student has to beg or make public request for money for them to go to law school. You want to be able to sponsor law school students, but you people are going to set up a company to do business. When you do business, you make profit, but the profit cannot be shared among the shareholders. They have to use that profit to now pursue a charitable objective. That's what we call a company limited by guarantee. Then for an unlimited liability company, it is a company that must have a share capital. Yes, for an unlimited liability company, it must have shares as well, just like a company limited by shares. And it's also designed to do business, make profit, and share the profit among the shareholders or the members. The difference between a company limited by shares and an unlimited liability company is the fact that one has limited liability, the other has unlimited liability. When the company, or if the company is in trouble and the assets of the company are insufficient to defray the company's debt, the creditors are allowed to turn to the personal assets of all the members or the shareholders of that company. And this is all I have for you guys today. So when you want to register or incorporate that company, you need to appreciate what type of company you are incorporating. Is it private? Is it public? And also you need to know the liability structure. Is it a limited liability and an unlimited liability? Also, you ask yourself, what exactly are you setting up this company to do? To enrich yourself? You are doing that to make money. Then you also know that you go for a company limited by by shares. And you should also know whether your company is a small company. And if you are the only person that wants to invest, you don't necessarily have to run it as a business name. You can always register a one-man company. I remain Yusuf Oluwafemi Salako, and thank you all for staying with me. Till I see you next time.